You are not mishearing this. On April 10th, 2026, British royal history recorded a milestone without any precedent. The Duke of Sussex has officially become a defendant at the High Court in London, and the entity taking him to court is not a tabloid or a disgruntled former employee. The plaintiff is Sentebale, the very charity he co-founded back in 2006 to honor his late mother, Diana, Princess of Wales. Just pause and consider the gravity of this situation. Let's look at the facts. Sentebale was established nearly 20 years ago by Prince Harry and Prince Siso of Lesotho, famously named after the Sesotho word for forget-me-not. For decades, it has operated with an annual budget of millions, supporting countless vulnerable children impacted by HIV and poverty in Lesotho and Botswana. What could possibly drive an organization with such a vital, life-saving mission to allocate its donor funds toward high court litigation against its own co-founder? The dossier we are opening right now examines an internal boardroom dispute that has escalated directly into the British legal system. As you watch this on the morning of May 1st, 2026, the legal filings are already a matter of public record at the Rolls Building in London. We are looking at a scenario that could become one of the most serious blows yet to Prince Harry's philanthropic image. The official response from the Sussex camp, delivered via a spokesperson, was brief and defiant, categorizing the lawsuit's claims as offensive and damaging. Behind that carefully worded statement, one can only infer the atmosphere at Montecito when a high court claim of this magnitude arrived at their doorstep. On the other side, the charity's current leadership appears resolute. According to the legal filings, Sentebale's board argues that recent actions and media strategies associated with the Duke left them with no choice but to take legal action to protect the organization's standing. This raises a crucial question that public relations experts are debating right now. At what point does a charity decide that confronting its royal founder in court is less risky than remaining silent? To understand how this reached a breaking point, we need to look at the mechanics of the claim. Sentebale is suing Prince Harry, alongside his longtime confidant Mark Dyer, under a Part 7 claim for defamation. The inclusion of Mark Dyer, a figure who was a steadfast mentor to the young princes after Princess Diana's passing, adds a deeply personal layer to an already high-stakes legal challenge. In the United Kingdom, defamation law places a significant burden on the defendant. Sentebale's legal team is alleging that statements orchestrated or encouraged by the Sussex camp created a narrative that actively disrupted their operations. However, it is essential to remember a core fact. At this stage, these claims remain allegations, not court findings. Whether Sentebale can conclusively prove that these actions directly caused quantifiable financial damage, such as major donors withdrawing their support, is a separate question entirely. That is the exact legal hurdle they must clear in front of a judge. If the case proceeds and is not settled quietly, the financial and reputational ramifications are substantial. A high court defamation loss could involve significant damages and legal costs, but even before any verdict is reached, the lawsuit itself poses a severe disclosure risk. The discovery process in a UK court can be highly intrusive, potentially forcing private emails and internal PR directives into the public domain. For almost 2 decades, Prince Harry's association with Sentebale was the cornerstone of his humanitarian identity. It was a tangible, legacy connection to his mother's charitable work. Today, that narrative has shifted entirely. The charity has now turned that very legacy into a direct legal and reputational challenge, and the next phase of this story will not be decided on television, but in documents, filings, and courtroom strategy. To understand exactly how the situation deteriorated to the point of high court litigation, we have to rewind the timeline to March 25th, 2025. This was the specific date the internal fractures finally became public. It began with a press release. Prince Harry and Prince Siso announced they were stepping down from their active roles at the charity, stating they were doing so with heavy hearts. But this was not a standard transition of power. In a highly unusual corporate move, 5 independent board members resigned alongside the royal co-founders on the exact same day. Let's be fair to the Sussex camp here and look closely at the facts. These 5 departing individuals were not personal employees of Prince Harry. They were independent trustees of a major charity. Their simultaneous departure strongly suggests that the internal dispute regarding the organization's direction was deep and multifaceted. It points to a broader crisis of confidence in the remaining leadership, rather than just a personal clash between the Duke and the board. At the center of this escalating power struggle was Dr. Sophie Chandauka, the chairwoman of Sentebale. Dr. Chandauka is a seasoned corporate lawyer and an experienced boardroom strategist. According to reports from the time, when the founding faction signaled that she should step aside to resolve the internal tensions, she firmly held her ground. She refused to surrender her position. This brings us to a crucial question that crisis public relations analysts are still debating today. When the royal founders and 5 board members walked out the door in a coordinated mass resignation, what exactly did they anticipate would happen next? Did they expect that the sheer weight of public opinion and donor pressure would force the chairwoman to yield? Or were they simply willing to walk away from the table to send a definitive message? History may judge that decision as either a principled stand or a highly consequential strategic miscalculation. Here is how the mechanics of that boardroom maneuver played out. By stepping down in protest and taking allied board members with him, Prince Harry did not dismantle the opposing leadership. Instead, from a purely administrative standpoint, he created an immediate power vacuum. By the morning of March 26th, Dr. Chandauka remained in her position, now operating without the primary counterbalance of the founding faction. Consequently, the remaining executive board retained full control over the organization's administrative infrastructure, its elite legal counsel, and its substantial operating budget. The very institutional framework that the Duke had helped build over nearly 2 decades was now firmly under the direction of the leadership he had just publicly broken ties with. From a reputational and legal standpoint, the decision to leave the boardroom rather than stay and navigate the internal conflict had a profound consequence. It inadvertently left Sentebale's current leadership with the undisputed authority and the institutional resources they needed to eventually escalate this boardroom dispute into a formal, heavily funded legal challenge. The coordinated resignations were only the beginning. 4 days later, on March 29, 2025, the private boardroom dispute was broadcast to the world. Dr. Sophie Chandauka sat down for an exclusive, live interview on Sky News with veteran broadcaster Trevor Phillips. During that broadcast, she did not rely on standard corporate public relations statements. Instead, she introduced highly specific, deeply damaging terminology into the public record. On live television, Dr. Chandauka publicly accused the Sussex camp of engaging in what she explicitly categorized as industrial-scale bullying and an abuse of power. But perhaps the most striking allegation was her use of the word misogynoir, a term specifically defining prejudice directed toward Black women. She alleged that the Duke had actively interfered with an internal whistleblower complaint, framing his actions during the broadcast as a royal cover-up. According to her narrative, when she refused to step down, she became the target of a coordinated media smear campaign orchestrated by what she termed the Sussex PR machine. It is critical to pause here and separate a televised interview from established fact. These were explosive allegations made on a morning news program, not sworn testimony in a court of law. Representatives for Prince Harry have categorically rejected these claims. The Sussex camp has consistently maintained that their departure alongside the 5 board members was rooted in legitimate, serious governance concerns regarding the charity's direction, not personal vendettas or discriminatory behavior. To anchor her claims in the court of public opinion, however, the narrative tapped into visual moments that had already circulated widely online. You might recall the viral footage from a previous Sentebale charity polo match. The clip showed Prince Harry holding a massive presentation trophy, while the Duchess of Sussex appeared to gesture for Dr. Chandauka to step aside and slide awkwardly under the cup just to fit into the celebratory photograph. This raises a fascinating question about media perception. Was this simply an awkward, unscripted few seconds during a chaotic, crowded photo opportunity? Or, as Dr. Chandauka's supporters argued, did it visually symbolize the dismissive, elitist dynamic she was alleging behind closed doors? Regardless of the actual intent behind that brief interaction on the polo field, the optics were immediately adopted by the press and used to bolster the chairwoman's narrative. Accusations involving systemic prejudice carry immense weight in today's cultural and media climate. For Prince Harry, a public figure who has built a significant portion of his global brand on advocating for mental health and speaking out against institutional bias, this presented a profound reputational challenge. The framing of the dispute had fundamentally shifted. The Duke was now publicly facing the exact type of allegations he had previously leveled at the British institution he left behind. At this stage, the conflict was no longer just a debate over who controlled a charity's board of trustees. It had become a high-stakes battle over whose version of reality the public, and eventually the regulatory authorities, would choose to believe. In August 2025, the Charity Commission for England and Wales released the findings of its independent 4-month investigation. The results of that regulatory probe fundamentally shifted the narrative, and the conclusions likely surprised observers on both sides of the dispute. To understand the current legal battle, we must look closely at the two core findings of that official report. First, the regulatory body stated explicitly that it found no evidence to substantiate the claims of widespread bullying, systemic abuse, or misogynoir orchestrated by the royal co-founder. This is a critical fact that any fair analysis must acknowledge. The most explosive allegations broadcasted by Dr. Shandauka on Sky News were not validated by the independent regulator. For Prince Harry, this offered a significant, formal exoneration on the most damaging personal charges. However, the Commission did not issue a simple, clean slate. The chief executive, David Holdsworth, issued a formal reprimand. The regulatory body firmly criticized both the current leadership and the Sussex camp for allowing an internal governance disagreement to play out so aggressively in the global media. The Commission noted that this highly public spectacle risked damaging the charity's overall reputation and, consequently, its ability to serve its beneficiaries in southern Africa. This brings us to a pivotal moment in the timeline. Following a mixed regulatory ruling of this nature, standard crisis management often dictates a period of strategic silence to let the controversy cool. But the Sussex camp chose a decidedly more assertive route. Following the publication of the report, a spokesperson for the Duke issued a strong public statement. While welcoming the clearance on the bullying claims, the statement also aggressively pushed back against the current Sentebale board. The Sussex camp reportedly labeled the initial allegations against the Duke as completely baseless and continued to publicly question the ongoing governance and direction of the charity under Dr. Shandauka's leadership. This specific public relations strategy is exactly what triggered the current High Court litigation. According to the legal filings submitted in April 2026, Sentebale's board did not view the Duke's post-ruling statements as mere self-defense. Instead, they cited these very press releases and the resulting media coverage as evidence of an ongoing, coordinated media strategy designed to actively undermine the charity's current leadership and disrupt its operations. This presents a fascinating dilemma regarding public relations and legal risk. Did the Duke's communications team feel it was absolutely necessary to fiercely defend his integrity in the press, regardless of the pushback? Or did they underestimate the legal appetite of the opposing board? Ultimately, the effort to decisively win the narrative in the media appears to have backfired. By continuing to aggressively litigate his innocence and criticize the charity's board in the press throughout late 2025, his team may have inadvertently handed Sentebale's lawyers exactly the material they needed to escalate the dispute. What began as a battle for public opinion had officially transformed into a formal defamation claim. This brings us to the current legal reality. On April 10, 2026, the formal defamation claim was officially logged at the High Court in London. When the public dockets became available, legal analysts immediately noted one specific detail that adds a deeply personal dimension to this corporate dispute. Prince Harry is not the sole defendant. Listed right alongside him is Mark Dyer. For those familiar with recent royal history, Dyer is a highly significant figure. Following the passing of Princess Diana, he served as a trusted equerry and a fiercely protective mentor to the young princes. Now, Sentebale's legal team has formally named him as a co-defendant, alleging his involvement in the media strategy against the charity's current leadership. Bringing a lifelong, trusted confidant into a high court battle illustrates exactly how complex and entrenched this dispute has become. The official posture from the Sussex camp has remained brief and resolute. Representatives have firmly pushed back against the lawsuit, previously categorizing the underlying claims as offensive and damaging. However, legal experts note that in the British judicial system, public statements are merely the opening moves on a much larger board. To understand the true risk this lawsuit poses to the Duke, we have to look past the daily headlines and examine the mechanics of UK civil litigation. If this case is not settled and proceeds toward a trial, it will trigger the disclosure phase. From a reputational standpoint, this is arguably the most precarious element for any high-profile defendant. During the disclosure process, Sentebale's legal team could petition the court for access to private communications directly related to the dispute. This means that internal emails, text messages, and strategic public relations directives sent during the turbulent months of 2025 could potentially be subpoenaed, scrutinized, and entered into the public record. In a civil court proceeding of this nature, there are no royal exemptions protecting private correspondence. If the case develops unfavorably for the Duke, the collateral damage could extend far beyond the courtroom and a potential financial penalty. The Archewell Foundation, his commercial streaming partnerships, and his broader brand identity are heavily anchored to his status as a global humanitarian. Navigating a defamation claim brought forward by the very charity established to honor his mother's legacy presents an unprecedented optical challenge. This is no longer a narrative that can be managed through exclusive televised interviews or sympathetic media placements. A high court courtroom relies entirely on documentation, timelines, and verifiable evidence. The conflict has officially moved out of the public relations arena and into a strict legal jurisdiction where rhetoric must be backed by proof. As the legal proceedings gain momentum in London, media analysts are paying close attention to a notable absence in the coverage: the official silence from Buckingham Palace. For decades, the British royal family has operated under a well-known institutional policy of refraining from public comment on personal disputes or ongoing litigation. In this instance, that traditional approach remains firmly in place. The lack of commentary or intervention from the palace may be interpreted by some observers as a strategic distance. It underscores the practical reality of the Duke's current position. Having stepped back from working royal duties years ago, he is navigating this complex corporate litigation entirely as a private citizen, without the institutional shield of the crown. As the legal teams prepare for the upcoming phases, legal experts are mapping out several potential trajectories for this unprecedented case. One scenario, often described as the highest risk path for both parties, is a full public trial. If the case proceeds to an open courtroom, the global press would be present as disclosed internal communications and public relations directives are analyzed in real time. For Prince Harry, navigating a public cross-examination regarding his mother's memorial charity would be a uniquely challenging optical and legal hurdle. Simultaneously, a prolonged public trial carries substantial reputational risks for Sentebale itself, as its internal boardroom dynamics would be thoroughly scrutinized. A second possibility is a technical legal victory or an early dismissal. If his legal team successfully argues that the claims do not meet the strict threshold for defamation, the case could be thrown out. However, even if the court rules in his favor on procedural grounds, the financial cost of defending a high court claim is notoriously high. Furthermore, the broader public relations challenge of having been sued by the charity would likely continue to be a subject of intense media debate. This leads many veteran legal analysts to point toward a third, highly common resolution in civil disputes of this nature: a confidential, out-of-court settlement. In this scenario, the parties might negotiate an agreement to withdraw the lawsuit before it reaches a courtroom. This route typically involves a financial settlement and, crucially, a strict non-disclosure agreement. If an ironclad NDA is implemented, it could legally restrict both the Duke and Sentebale from ever discussing the dispute or potentially each other in the future. This outcome would effectively and permanently sever his public association with the organization he helped build. At this moment, the civil claim is officially active on the High Court docket. What matters now is no longer the public relations war, but what can actually be sustained under legal scrutiny. The next phase of this story will not be decided by press releases or televised interviews, but by sworn documents, evidence discovery, and courtroom strategy. Will this unprecedented dispute be quietly resolved behind closed doors to protect the charity's legacy? Or is the public about to witness a historic legal confrontation in London? The answers lie in the legal filings currently being processed. Hit the subscribe button and turn on notifications to follow our ongoing investigation as this complex legal challenge continues to unfold.